So we are ready for class. All right. Uh, hmm. अरे कोई यस येट भी लिख दो, नो येट, नो येट क्या है? यस येट. तो पहले सच्चाई से बताओ, डू यू पीपल अंडरस्टैंड सीपीसी नाउ और नॉट? कुछ समझ में आता है, नहीं आता है? वेदर यू आर एबल टू अप्रिशिएट सीपीसी और नॉट, फर्स्ट लेट मी नो दिस. अदरवाइज पोथी पढ़ी पढ़ी जगमुआ, पंडित भयानक होय. ढाई आखर बेयर एक्ट के जो पढ़े वही पंडित होय. So do you understand the CPC or not? Let me know. Let me know. कुछ समझ समझ में आता है कि नहीं? Hmm? You tell me sincerely whether your teacher is able to teach you properly or not, whether he is able to convince you or not, whether he is able to tell you that the CPC is simple or not. CPC is a simple procedure code, no? CPC is simple procedure code. So I think now process can be understood, and you must have understood the process. I hope so. And the things which we are studying. Are Ajay Chaudhary, very good. Thank you, my dear friend. Understanding very well. Good. God bless you, sir. कुछ तो बच्चे मेरे को समझते हैं. चलो अच्छी बात है. Most of them are not writing anything. It means they do not understand my language, my voice. You understand or not? You let me know. कुछ समझ में आ रहा है, नहीं आ रहा है? कुछ कुछ तो समझ में जरूर आ रहा होगा, नहीं? कुछ कुछ तो आ रहा है सर. बहुत बढ़िया, बहुत बढ़िया. You will understand everything, but just have confidence, courage. वाह संदीप जी, thank you very much. uh, I need such Divyans Mahajan, very good. Shalini Jha. Sambhavi, Shreya, सिमरन, भारती, नंदिनी, गरिमा. और लोगों का मैसेज कहाँ चला गया यार, पता नहीं. स्पृहा श्रेया, हरितमणि गुरुचर्या, प्रियंका, अल्फिशा. All right. Gyanendra Singh, thank you, sir. God bless you. Nisanji, so benevolent in your appreciation. Anupma, we are trying to make your task easy. Happy Sony, Mohammad Soeb, Ujjwal Sandilya. Thank you, my dear friend. अब तुम लोग एक दिन टाइम निकालो, मेरे से मिलने भी आओ. अब ये क्लास ऑनलाइन ही है, बट अरे भैया अभी तो शुरू किया दिव्यांश महाजन जी, अभी से कहाँ डीमोटिवेटेड एंड एंक्शस होने लगे. यू हैव नॉट प्रिपेयर्ड एंड यू हैव अपीयर्ड इन एग्जामिनेशन. यू हैव नॉट लर्नड स्विमिंग एंड यू jump into this now swimming pool. So is it advisable? No. कीर्तिमान द्विवेदी, अग्ना पटेल, दिव्यांश महाजन बिल्कुल नहीं. प्रियंका सिंधु, सागर, मोहम्मद आमिर, भूमिका. Very good. Thank you very much, my dear friends. God bless you. Where are others? They are not here. Okay. हमें तो काम करना है. We are here. Little late, but even then we are here. So we were understanding this summons question. Yes. Bharti Kumari, Aarti Tiwari. All right. Cakewalk. Thank you, Aarti, so much. Thank you so much. Now, the question is, I answered the question yesterday. Kanika Goel. Now let us begin with this topic which we were discussing yesterday, my dear friend. We started with this proposition that after plaint is filed, court is seized with the matter, then the next step on the court's part is to call the other party. Because the rule is audi alteram partem. You must hear the other party. If you do not hear the other party, you cannot give judgment on any point. So you must hear the other party. Is this clear? So we read yesterday about various points in summons. Let us proceed further. Now let us see section 27, 28, 29, 30, 31 and 32 little bit, because now we'll be raising question related to that. So now the question is issue of summons to defendant who resides outside in another state. So what is the provision for issuing summons to a person who is residing outside state? So section 28. And in that what you do, so you have written that we'll send the summons to the court concerned, and that court concerned will send it as if it has been issued by that court. So this court will send summons to that court, and that court will send the summons as if it was issued by that court. And then whatever is the proceeding, whatever is done, then that will be sent back to the original court which issued summons. Now then the next question is, how will we issue summons, or which section will apply when summons is served at a place where CPC does not apply? Where CPC does not apply. So section 29 is the provision. Section 29 is the provision, and summons CPC does not apply. So CPC does not apply, then in that case you will issue summons as per section 29. It is written also, service of foreign summons. Summons and other processes, not only summons, other processes also, whatever it may be, that will be dealt in section 29. Not so important, but just you have a glance. Not important, by the way. And then the question is that what will be the rule in case of issuing of summons to a witness? I said you yesterday also that summons to witness is dealt there in Order 16 of CPC, and here is the provision in section 31. Section 27, 28, 29 will apply because 30 is related to order to discovery, etc. And when you do not comply with the summons, what is the process to be followed in that case? When a person, now I called you by issuing summons and you do not come to the court. So what is the recourse left to the court? So answer is in section 32. So it says court may compel the attendance of any person to whom a summons has been issued under section 30 and for that purpose may issue a warrant for his arrest. So penalty for default. No? इसमें भी summons है, section 30 में भी power to order discovery and the like. Issue summons to person whose attendance is required, either to give evidence or to produce documents. Is written here, section 30. Now, can you see this clause B? So in such a case where summons is not complied with, so it says then you can issue arrest warrant or you can attach and sell his property, impose a fine not exceeding 5,000 rupees and order him to furnish security for his appearance and in default commit him to civil prison. So that is what is the point, you know. You can obviously adopt a harsher process, that is arrest warrant, attach and sell his property. You can sell his property, you can impose a fine, or you can even detain him. So that is the law on the point. Now, if you are asked a question, what are the different rules relating to summons? Or you can be asked a question that write a short notes on issuance of summons. There can be various kind of questions in your examination. Nothing great. It can be a question that write short notes on issuance of summons, or what are different methods of issuing of summons, what are different processes of serving summons. So there can be variety of questions. So we'll address them one by one. Let us see a little bit on this now. So let us raise questions and let us answer them. Let us raise questions and let us answer them. Now, there is a question which has been asked in your examination. Discuss various modes of service of summons. So let us raise questions and let us address them. Discuss various modes of service of summons. This is the question. Now we are required to answer this question. So it will cover various provisions, so you'll have to concentrate and you will have to look into your barrack also and you will have to listen to me also. So service of summons can be direct and service of summons can be substituted. So you write down service of summons can be direct or substituted. Service of summons can be direct or substituted. Service of summons can be direct or substituted. What is this direct service? So direct service can be personal service. You go and serve on summons, summons on the person concerned, that is personal service. Extended, you can serve it on others also. Or there can be substituted service without court's permission and with court permission. We'll just see this. Now, personal direct service, direct personal service. So you write down one by one. Direct personal service is the most preferred mode, of service of summons. Direct personal service is the most preferred mode of service of summons. of service of summons. Direct personal service. That is, summons is served personally. That is, summons is served personally to the defendant or to his authorized agent. Summons shall be served personally to defendant or his authorized agent. Is this clear? Then write down, if they reside within the jurisdiction of court, if they reside within the jurisdiction of court, then it will be served by, then it will be served by, then it will be served by bailiff or process server. Then it will be served by bailiff or process server. Then it will be served by bailiff or process server. Then it will be served by bailiff or process server. Then it will be served by bailiff or process server. Or by post registered, or by registered post with acknowledgement, or by speed post, or by courier service approved by High Court. Courier service approved by High Court. Or even by email. Now even by WhatsApp. A recent rule, I will see where it was said, but it was reported in the newspaper that you can serve even it by WhatsApp. So now this is in consonance with evolving technology. It can be done even by evolving technology. If defendant does not reside within, if defendant does not reside within the jurisdiction of that court, if defendant does not reside within the jurisdiction of that court, then as per Order 5 Rule 21, as per Order 5 Rule 21, you can see Order 5 Rule 21, it says summons may be sent by the court by which it is issued, whether within or without that state, either by one of its officer or by post or by such courier service as may be approved by High Court, or by fax or by EMS or by any other means as may be provided by the rules made by the High Court, to any court not being the High Court having jurisdiction in the place where defendant resides. Where defendant resides. So it says, as per Order 5 Rule 21, summons may be sent to the court. Summons may be sent to the court within whose jurisdiction, if summons may be sent to the court within whose jurisdiction within whose jurisdiction the defendant is found, the defendant resides, either by its officer or by post or by approved courier service or by fax or by email or by other means. Other means may include even WhatsApp, no? Or by other means approved by High Court by rules. Approved by High Court by rules. Approved by High Court by rules. Is this clear? You can see in this regard Order 5, Rule 9 also. Order 5, Rule 9 also. Like Sub-Rule 4 says there, notwithstanding anything contained in Sub-Rule 1, where a defendant resides outside the jurisdiction of court in which suit is instituted and the court directs the service of summons on that defendant may be made by such mode of service as is referred to in Sub-Rule 3, except by registered post acknowledgement due, the provision of Rule 21 shall not apply. So, notwithstanding anything contained in Sub-Rule 1. Now, Sub-Rule 1 talks of defendant resides within jurisdiction of court in which suit is instituted or as an agent resident. So, that is a very simple case. Who is empowered to accept the service of someone? The summons shall be delivered or sent either to proper officer to be served by him or one of his subordinates to such courier service as are approved by the court. So, that is general. Order 5, Rule 9, Sub-Rule 1 is general, where defendant resides within jurisdiction. And Sub-Rule 4 says that where a defendant resides outside jurisdiction, and court directs that the service of summons may be made by such mode of service as is referred to in Sub-Rule 3. Sub-Rule 3 is by registered post acknowledgement due, no, or by speed post or by courier service as approved by High Court. So, if these are courier service, etc., it needs approval of High Court. Or by any other means of transmission of document, including this fax or EMS, provided by the rules made by the High Court. So, High Court can make rule regarding that. So, notwithstanding anything contained in Sub-Rule 1, where a defendant resides outside in which suit is instituted, court directs that the service of summons on that defendant may be made by such mode of service of summons as is referred to in Sub-Rule 3. So, Sub-Rule 3 is the provision where you can serve a summons on any person residing outside. Is this clear? Sub-Rule 3, where he resides outside. So, outside, in that case, Order 5, Rule 3. Now, Order 5, Rule 3 is applicable, and Order 5, Rule 3 says that service of summons may be made as per this speed post or by courier service or by other means of transmission like electronic mail service or otherwise, no? All these provisions are applicable in such situation. ये सारे provisions वहाँ लागू होते हैं. Is this clear? So you can send the summons. You can send the summons You can send the summons by such method. Delivering or transmission copy of registered to the defendant or his agent empowered to accept. So here you are transmitting it directly, if you see carefully. And rule 21 you see, it says summons may be sent by the court by which it was issued, whether within or without the state, either by one of its officer, or as may be approved by High Court, or by fax message, or by as may be provided by the rules made by High Court to any court. So rule 21 says that you can send summons to any court, whereas order 5 rule 9 says that service of summons may be made by these methods. Now directly also resides outside the jurisdiction. So you can send him directly. So you can send him directly also. So order 5 rule 9 contemplates service of summons to person residing outside the jurisdiction of court directly. Or rule 21 contemplates a situation where a court will send summons to another court to be issued. So that court will further issue the summons, further send the summons. Summons has been already issued by one court. Now this court to which I have sent, it will further release it as per order 5 rule 21. I hope you understand. Order 5 rule 9 direct and order 5 rule 21 through court. So you can write down also like this, through court. And order 5 rule 9 direct. Both cases it is to person outside. Is this clear? Another court through another court. Now then read further. Just have a glance, nothing great. Now, then see service within presidency town, and then this presidency towns like Calcutta, Madras, Bombay, etc. Now, rule 23, the court to which a summons is sent under rule 21 or 22 shall upon receipt proceed as if it is issued by such court, and shall then return the summons to the court of issue together with the record. So, write down further. As per order 5 rule 23, as per order 5 rule 23, if the summons is sent to another court, then it will be deemed that it has been issued by that court. Then it will be deemed that it has been issued by that court. Then it will be deemed that it has been issued by that court. Then it will be deemed that it has been issued by that court, and it will be served by that court accordingly. 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 And it will be served by that court accordingly as it had issued the summons. And it will return the summons with the proceedings, with the record of proceeding, and it will return the summons to the issuing court. It will return the summons to the issuing court. And it will return the summons to the issuing court along with the record of proceedings. along with the record of proceedings. Just see Order 5, Rule 23, nothing great. Then see Order 5, Rule 24, service of defendant in prison. So if defendant is in prison, then the summons shall be delivered or sent if the defendant is in prison, then the summons shall be served or delivered through officer in charge of prison. Through officer in charge of prison. Through officer in charge of prisons. Through officer in charge of prisons. तो किसको दोगे? ऑफिसर इन चार्ज ऑफ प्रिजन को. नथिंग ग्रेट, वेरी सिंपल. If I have to serve summons on a prisoner, then I will serve the summons on officer and he will serve upon him. He is the boss, he is officer in charge of the prison, so I will give him. Service where defendant resides out of India and has no agent. So, if defendant resides abroad and has no agent in India, if defendant resides abroad and has no agent in India, then summons shall be sent. Then summons shall be sent. Then summons shall be sent to him by post. Then summons shall be sent to him by post or by any other method, approved by High Court, or by any other method approved by High Court, to the place where he resides. To the place where he resides. Is this clear? थोड़ा बहुत समझ में आ गया? Order 5, Rule 9, Order 5, Rule 21, Order 5, Rule 22, Rule 23, Rule 24, Rule 25. So just see Order 5, Rule 21 to 25 and Order 5, Rule 9. You should have seen that. You should have seen that. Just read them. You have read all these rules, I hope. No? We have just seen it. अब देखो, there are other kind of service also, substituted service, no? There is substituted service also, which we call substituted service. Substituted service, personal service, substituted service. So situation of substituted service क्या है? So let us see this Order 5, Rule 17. Just have a glance, kuch hai nahi. In this provision, you are required to just read the provisions. There is no concept, it is information. It is not conceptual, it is informative. Oh, teacher doesn't have much role in such things where there is no concept, only information. So you can read yourself also, where the defendant or his agent or such other person. I am reading Rule 17 of Order 5. As aforesaid refuses to sign or acknowledge क्या करेंगे? He doesn't accept, so there is no personal service. Or where the serving officer, after using all due really cannot extend the defendant, so there is no extended service. Who is absent from his residence at the time when service is ought to be effected on him at his residence, and there is no likelihood of his being found at the residence within reasonable time, and there is no agent empowered to accept the service on his behalf, so there is no extended nor any other person on whom service can be made. The serving officer shall affix a copy of summons on the outer door. So what he will do? You see Order 5, Rule 17. It says, the serving officer shall affix a copy of summons on the outer door or some other conspicuous part of house in which defendant ordinarily resides or carries on business or personally works for gain, and shall then return the original to the court from which it was issued, with the report endorsed thereon and annexed thereto stating that he has so affixed the copy. So this is what it's now a substituted service. So substituted service means, you can write down substituted service. Substituted service means service of summons. Substituted service means service of summons service of summons substituted service means service of summons substituted service means substituted service means service of summons service of summons instead of service of summons substituted service means service of summons instead of personal service. There is no personal service, instead of personal service. Order 5, Rule 17. Order 5, Rule 17. Where either the defendant or his agent, where either the defendant or his agent where either the defendant or his agent refuses to sign the acknowledgement, refuses to sign the acknowledgement, or where serving officer is not able to find, or where serving officer is not able to find defendant despite due diligence, despite due diligence as defendant is absent, as defendant is absent, as defendant is absent, and there is no likelihood of his returning within reasonable time, and there is no likelihood of his returning within reasonable time, and furthermore, there is no authorized agent on whom summons can be served. There is no authorized agent upon whom summons can be served. Then in that situations, then in that situation, then in that situation, then in that situation, if the above conditions, then in that situation, substituted service can be adopted. Then in that situation, substituted service can be adopted. Then in that situation, substituted service can be adopted. And in substituted service, summons shall be affixed on the outer door or any other part of conspicuous house, or any other part of conspicuous or any other conspicuous part of the house, or any other part of conspicuous part of the house. Conspicuous part means eye-catching. Like you go and affix the summons on the main door. So this is visible to everybody, conspicuous part of the house. Conspicuous basically means that eye-catching. Easily it can be noticed. So conspicuous part of the house, not on the hidden side. No, 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 no. Conspicuous part. So main door or entry point. So conspicuous part. Conspicuous part of the house. Like now residence or business or work, for again you have just seen. Place of residence, place of work or business. And thereafter the original will be sent back to the court with the endorsement. Endorsement means basically signature. Endorsement means signature. And the original will be sent to the court with the endorsement along with the circumstance in which substituted service was adopted. Along with the circumstance in which substituted service was adopted. Along with the circumstance along with the circumstance in which substituted service was adopted. Is this clear? And for this purpose, process server can declare by affidavit or otherwise that someone has been duly served. That summons has been duly served. Summons has been duly served. That summons has been duly served. If court is not satisfied, it will further examine the process server. If court is not satisfied, process server will give affidavit regarding this. But if court is not satisfied, it will further examine the process server. So Order 5, Rule 17 talks of this. Now, this was Order 5 Rule 17. Now then see further Order 5 Rule 20. Order 5 Rule 20. This again deals with substituted service. Second method of substituted service. When the court is satisfied that there is reason to believe that the defendant is keeping out of the way for purpose of avoiding service, or that for any other reason, the summons cannot be served in the ordinary way. Ordinary way is generally by process server and all other methods. The court shall order the summons to be served by affixing a copy in some conspicuous place in the courthouse, and also upon some conspicuous part of the house in which defendant is known to have last resided, or carried on business, or personally worked for, or in such other manner as the court thinks fit. Where the court acting under sub-rule 1 orders service by an advertisement in a newspaper, the newspaper shall be a daily newspaper circulating in the locality in which the defendant is last known to have been actually and voluntarily residing, carried on business, or personally worked for gain. So you can write down second method of substituted service. Where court is satisfied that the defendant is keeping out of the way, where court is satisfied that the defendant is keeping out of the way, where court is satisfied that defendant is keeping out of the way, then in that case, court may order the court may order. अब देखो यहाँ ऑर्डर करेगी कोर्ट. रूल 17 डज नॉट टॉक ऑफ द ऑर्डर ऑफ द कोर्ट. It doesn't talk of the order of the court. In Rule 17, the decision has to be taken by the serving officer. No? He has to satisfy the court later on. In Rule 20, the order of the court is the first condition. No? If there is ground that this person is avoiding the service of summons, then Rule 20 comes in picture. So I said if the defendant actually avoids or keeps away from the service of summons, and then the court has to make an order. Then the court has to make an order to serve summons by affixing a copy in some conspicuous place. Conspicuous place. Conspicuous. I said eye-catching. Conspicuous. Can you see in your barrack or not? Conspicuous place. Where? Of courthouse. And house also, if any. Conspicuous part in the courthouse and also upon some conspicuous part of the house, in which defendant is known to have resided last. In which defendant is known to have resided last. House in which defendant is known to have resided last. Defendant is known to have resided last. Or carried on business. Or carried on business. Or personally worked for him. So last resided. Resided last. So at present he is not getting now this. You're not getting his house, but you know that now where he was residing last. So there you can. Is this clear? Rule 20. I will request you to look into those rules once. Where the court acting under sub-rule 1 orders service by advertisement in a newspaper. So it can be done even by, it can be done even by, it can be done even by, it can be done even by advertisement in newspaper. It can be done even by advertisement in newspaper. Is this clear, my dear friends? It can be done even by advertisement in newspaper. Can plaintiff also serve summons? Yes. Order 5, Rule 9A. Order 5, Rule 9A. Can plaintiff also serve summons? Yes. Summons given to plaintiff for service. The court may, in addition to service of summons under Rule 9 on application of plaintiff for issue of summons for appearance. These summons are also known as dusty summons. देखो ये सब question पूछ लेता है preliminary में. Service by plaintiff, dusty summons. Rule 9A. This is kind of questions which will be asked to you in examination. Service of summons by plaintiff. And if plaintiff serves summons and the defendant does not accept, then the court will issue summons, all right. Then the court, here there is no presumption in this case. If you go and you are not able to serve summons, then the court will presume service of summons because you are avoiding this. तो ये नहीं चलेगा. But if plaintiff serves summons and you do not receive it, court will not presume summons served. Rather, the court will issue summons. But this is given in Rule 9A of Order 5. Rule 9A of Order 5. Acha, are there any person exempted from issuance of summons where the summons will not be served? Yes, if you can look into the provision of section 135A. Now, is this exempted from personal appearance before the court from summons in CPC 132, 133? 132, 133. 135A is exemption from arrest and detention. 132, 133. Can you see 132, 133? 132, 133. Exemption of certain women from personal appearance. I'll teach you again this. Exemption of other persons. Just see this. Just see the category. I'll tell you how to memorize this 133 and 132. 132 I'll be teaching again, but don't worry. 133 you can see exemption of persons. These are all now higher dignitaries, that is, not great judges and president and vice president, ministers, governors, administrators, speaker, chairman, all these people. So just look into section 132, 133. Exemption from personal appearance. Exemption from personal appearance. So, um, so you cannot ask them to come before the court. No, you cannot issue summons to them. Time for issuance of summons 30 days within the institution of suit. Within the institution of suit. You have seen it, I hope. I hope you have seen it. So substituted service at two places, Order 5 Rule 17 and Order 5 Rule 20. Personal service, Order 5 Rule 9 and 9A. Extended service, Order 5 Rule 15. Order 5 Rule 15, extended service, Order 5 Rule 15. Can you see this Order 5 Rule 15, extended services? We should not forget anything, just have a look, glance. Order 5 Rule 15, when service may be on adult member of defendant's family. So when you are not found, then somebody of adult family, servant is not a member of family, so you cannot serve summons on him. Adult member of family, whether male or female. If you see CRPC, you cannot serve summons on female there, but here it can be done. It can be adult male member, adult female member. Extended service in Order 5 Rule 15 also, where you serve it on family member. Family member. अब मैंने बहुत सारे रूल्स आपको पढ़ा दिए हैं. Just have a glance. Just have a glance. Have 10 minutes break. I will join you, but till that time, you just look into Order 5, all rules quickly. And I'll deal with that Rule 30 also. And I'll tell you how to memorize Section 133. You just go through entire provisions. Order 5 Rule 15 is extended service, where you can serve on adult male member or female members. Is this clear? So just have a glance, I come back. 10 मिनट के लिए रुकते हैं और फिर पढ़ते हैं. So we are doing this order 5. Now you tell me, my dear friend, order 5, rule 1 to 30. If you have any issue, any question on that point which we have dealt with, you please look into that. Order 5, is it clear till the point we have covered? There is nothing left now, I hope so. I will discuss with you a few more things. As far as time of issuing of summons is concerned, I have said that it should be done within 30 days primarily. No? But then there is further provision which says that it can be may be satisfied for reasons to be recorded, but it shall not be later than 90 days. Not later than 90 days. So 30 days and 90 days. Is this clear? "30 days and 90 days. Is this all right? So generally 30 days, but you can go beyond 30 days and it can be also 90 days. भाई देखो, हम भगवान तो है नहीं. Can there be men's question from order 5? How can I say yes or no? But I have told you men's question also. यदि मैंने अभी शॉर्ट नोट्स आपको लिखाया है, आप क्लास में नहीं है एनस? आर यू नॉट इन क्लास? नहीं है क्लास में, आप कहीं और थे. क्लास में हैं. अभी मैंने लिखवाया है ना, इतना सारा चीज बताया. मेंस में भी आता है तो भी लिख दोगे, लेकिन ऐसे सवाल कोई है नहीं कि मेंस में आएगा. कि प्रिलिमिनरी में कोई भविष्यवाणी थोड़ी कर रहे हैं. आई एम नॉट ज्योतिष, नो. कहीं भी आएगा मैं तो जवाब दे दूंगा. इंटरव्यू में पूछ लोगे, इवन देन आई विल आंसर, बिकॉज यू विल आस्क मी कॉन्सेप्ट. आई सेड जनरली ऑर्डर 5 इज रेलिवेंट फॉर प्रिलिमिनरी. देखो यही है ना, समझ का फेर है बहुत. अब तुम हमसे पूछ रहे हो विल यू नॉट बी आस्क्ड, और कल को मेंस में आ जाएगा, देन यू विल से सर इट हैज बीन आस्क्ड इन मेंस. Oh. भाई 120 डेज कमर्शियल सूट्स में लिखा है, आप गलत नहीं पढ़ो. प्रज्ञा राय, फर्स्ट रीड देन कमेंट. नो नो, इट इज नॉट रिटन. वो कमर्शियल है, स्पेशल अमेंडमेंट. वी आर नॉट रीडिंग दैट. कितने बच्चे हो आप लोग भाई. अभी आप लोग पढ़ने में आप लोग समय लगेगा. यू आर नॉट रीडिंग एट ऑल नाउ. आप एकदम बच्चे की तरह सवाल पूछ रहे हो बिना क्लास में. इफ यू कम विदाउट प्रिपरेशन इन क्लास, देन यू विल आस्क सच क्वेश्चन. सी, वी स्टार्टेड इट यस्टरडे. एंड पढ़ा ही नहीं हमने इसको अभी तक अच्छे से. पढ़ा ही नहीं हमने अभी तक. हमने नहीं पढ़ा. देखो, आप जब तक till the point you do not study with me, see, teacher has to be very sincere and serious. And teacher has to study a lot to teach his student. Obviously, teacher is the best teacher has to be best student. If he doesn't prepare all the questions, all the answers, he will not be able to teach you. We are not dealing with the special amendment. So the special व्यवस्था है that in commercial disputes it can be done. But that is not the law. We are reading law. Order 5, rule 1 very clearly says. देखो इसमें किसी को भी अब ये भी पूछ रहे हैं Oh, sir, which provision says 30 or 90 days, Divyansh Mahajan ji? कीर्तिमान द्विवेदी एक अलग सा क्वेश्चन पूछ रहे हैं. कोई नहीं, आप ऑर्डर 5 रूल 1 को पढ़िए तो सही, पढ़ने की आदत डालो यार सर. Why don't you read, sir? Sir, you should read it. You should read it, sir. ये बच्चों की तरह सवाल खाली. 30 days is general. 90 days it says that order 5 rule 1 सब तो कहता है, आपने पढ़ा ही नहीं. कल ही मैंने order 5 rule 1 की चर्चा की थी. I discussed it yesterday. का मतलब टीचर पढ़ेगा बट आप नहीं पढ़ेंगे, ऐसा नहीं चलता. ये you are preparing for judicial services examination. You have to be very, very serious and sincere. It is not your college days, sir. Come out of that phase. Teacher will teach and you will do this and that. That cannot work here. ये यहाँ नहीं चलेगा. You read order 5 rule 1 first. आप पढ़ो. अभी सबसे मैं कह रहा हूँ, you all of you read order 5 rule 1 for 5 minutes. पढ़ो. मैं I'll stop here. You read first order 5 rule 1. Then we'll answer and address these questions with the special amendment. You read order 5 rule 1, and if you have ambitions, bear act. You see the clarity of language which we have written there. Why don't you read it carefully? I have written it in great detail on page 85. Page 85, I have written it in great detail, sir. You read it first. 5 minutes time for reading. You read it. Then I will discuss. Order 5 rule 1. सबको clear हो गया? Order 5 rule 1. अरे बंद क्यों कर दिया भाई क्लास? Order 5 rule 1 everybody has read now. So that is what I am saying, my dear friend. I am not running with the course. Let me tell you one thing. I am not running with the course. I am teaching you very slowly and very steadily and very elaborately. So you please read order 5 rule 1 and you read the notes. देखो कितना अच्छे से, ऐसे ही नहीं कह दिया आपको. देखो how I have written the complete thing. You are asking me the question. It is all answered here, sir. Summons क्या है? That is what is written. Then it is written, this appearance and answer must be made within 30 days and may be extended to further such period as may be granted by the court, not beyond 90. Therefore, further 60 days extension may be granted. This does not mean that no further extension may be granted after the period of 90 days is over, but it must be made only in exceptional circumstances if the defendant satisfies the court of an exceptional cause for not appearing that he was not negligent. It is not necessary to issue summons when the defendant is in the court at the time of presentation and admits the claim. I have explained this point also yesterday. And commercial dispute, which you were telling, my dear friend, commercial dispute, Pragya. So in commercial dispute, they have said 120 days. Is this clear? Personal appearance, order 5 rule 3, you have seen this. Copy of plaint annexed to summons that you have to send, that you have seen already. No party to be ordered to appear in person unless resident within certain limits. Now see here, this may be important again for prem. No party shall be ordered to appear in person unless he resides within local limits of court's ordinary. So if he lives within the limits of court's jurisdiction, then he can be asked to appear personally. Without such limits, that is beyond such limit, but at place less than 50, or where there is railway or steamer communication or other established public conveyance for 5/6 of distance between the place where he resides and the place where court is situated, less than 200 miles distance from the courthouse. So you just see what is written in rule 4. I just explained to you, my dear friend. It says no party shall be ordered to appear in person. No personal appearance. In which case? This can be a good question. No personal appearance in which case? So it says answer is there. Unless unless less than 50 miles. This is one. And number two, less than at place less than 50 or less than 200 miles. Less than 200 miles. But out of these 200 miles, less than 200 miles. Less than 200 miles. Unless 5/6 of distance, 5/6 of distance, 5/6 of this is covered by public conveyance, railway or steamer, no? Railway or steamer or public conveyance by bus, etc. You see, there are many places in India where you do not have communication system. So people from far-flung areas, if they are compelled to come before the court where they reside 200 miles away from the court, what will happen to them? Just think of. I think 5 miles equal to 8 kilometers. So this is almost 320 kilometers. So if you ask people to come from 320 kilometers, what will happen? So it says that in 320 kilometers, 5/6 should be covered by public conveyance at least. So even if somebody is coming from area which is far-flung area and hilly area and where there is no, one of my student who is there in Himachal Pradesh, he told me once, stop writing in chat, my dear friend. What are you writing? We submitted. क्या लिखा है ये? 30 to 90 days भारती सैनी. मैंने बता तो दिया यार, पढ़ो ना, क्यों लिख रहे हो इसी बात को? General rule is 30 days, then 90 days. It can be even beyond 90 days, but for that exceptional reason. So it can be 30 days generally, then 90 days, even beyond it. पढ़ो ना, पढ़ते क्यों नहीं हो? थोड़ा पढ़ने की आदत भी डालो दोस्त. भारती, थोड़ा सा मेहनत करना पड़ेगा दोस्त. देखो, मैं तो तुम्हारे लिए मेहनत करूंगा, बट थोड़ा सा तुम भी करो, मजा आएगा. Even beyond it, for exceptional reasons. अभी तुमको बताऊंगा सलेम बार केस. I'll teach you Salem bar case. I'll quote Supreme Court judgment on this point, don't worry. But not in this topic, I'll do it in written statement. I have got this page with me. I tell you, I got this page with me. Oh, where is the page? Oh. So I was saying that one of my judge student told me that somebody who was there involved in a case, pages, involved in a case. See, this is what I have with me. Now, you are asking the question. I have already ready material. With me, and here is Salem Advocate Bar Association versus Union of India. Chief Justice B.N. Kripal, Y.K. Sabrawal, Arijit Pasayat. Now, they have already delivered a judgment on 25/10/2002 when this question was raised. And they have already answered this question, which you are asking me here, my dear friend. Which you are asking me here. I'll give you this, don't worry, I'll give you this. So just I was telling you that he shared a beautiful experience. Let's see in a court. What happens in a case, I tell you that in that case what happens, that a person is coming to the court and he asks the court that please give me relief today itself, or you give me punishment today itself. I cannot come again to the court. The court was really concerned about this fact, that why this person is requesting this thing, that either you finish this case today or you punish me today itself. I cannot come again. So when question was put to him, then it came to the knowledge of the judge that he comes from far-flung area of Himachal Pradesh. And when he comes from far-flung area, then in that case, ये आपने गलत दे दिया मुझे. I have given you citation of SCC. You see that judgment of SCC, I have written in your WhatsApp. आप मुझे वो दीजिए, गलत दे दिया आपने. So, I tell you, my dear friend, that he said that in coming to the court, I have to travel on foot almost 10 to 12 hours, and I have to cross almost a pahadi. And then I will get a bus, and then I'll come to your court. And bus will also take in now mountainous region many hours to come to the court. And then I will take another 1 day to go back to my house. So it's really very, very difficult for me to come like this. And he lives in far-flung areas, and he is a very poor person, a villager. So now he says that no, I do not want to come again. You decide it today or punish me today itself. I cannot come again. So see the irony. See the situation. In such a situation, you have to take a call. In such a situation, you have to take a call. How can you decide this matter? 30 days, then 90 days, even beyond that. That is all right. That is all right. That is all right. 30 days or 90 days or even beyond that, that is all right. But here the question is about personal appearance. Now, on personal appearance, I told you that every time you're going to ask for, if he lives within 50 miles, okay. But if he lives within 200 miles, then what will you do? So, court says that if 5/6 distance is covered by public conveyance, then I will ask him to appear in the court, otherwise not. Otherwise not. Unless resident within certain limits. So you just read this, and there are certain provisions where there is an exemption from personal appearance, such as 132 in case of women and 133 in case of 133 in case of other person like president, vice president, president, vice president, president, vice president, minister, administrator. So see, higher officials, judges. So you can remember very easily, I think. Let us see 133. These are preliminary questions. And don't ask me that it will not come in mains. I can't predict. If the examiner wants to ask this in mains, how can I prevent him? So my dear friend, your question is very genuine, but you do understand what I say. I said that these things, if you ask this question in mains, will it be good? But you can ask anything. I can't prevent them from asking. I can't say to the examiner that you please don't ask this because I have said this in class. But generally, this kind of question is not expected in mains examination. Following persons shall be entitled to exemption from personal appearance. 133. President, Vice President, Speaker, Minister of Union, Judges of Supreme Court. Now, so this is related to Union. In Union, President, Vice President, all ministers of Union. So it includes Prime Minister, Central Minister, Cabinet Minister, Deputy Minister, Chief Minister, Cabinet Minister, State Minister, Independent Charge, all ministers. Judges of Supreme Court, Chief Justice and Judges. Then governor, then state, governor of state, administrator of union territory, speaker, chairman of legislative council, minister, judges. So this is again related to now 6 to 10 related to all state dignitaries. Governor, administrator is in union territory, speaker of legislative assembly, chairman of state legislative council, ministers of states, judges of high court, person to whom section 87B applies. Section 87B, I think that it is related to princely state, something like that. Now in India, we had many princely states earlier. So these are basically preliminary questions. Rulers of former Indian states. No? Former Indian states. Like Junagadh, Hyderabad, all this, Kashmir, no? So these are exempted people, 133. Is this clear? And 132 in case of certain women. It says women who according to the custom and manner of a country ought not to be compelled to appear in public shall be exempt from personal appearance. So 132 is also now, they can ask you question. 132 is related to Pradhanashin. Nothing contained shall be deemed to exempt such women from arrest in execution of civil process in any case in which arrest of woman is not prohibited by. But in execution, she can be arrested. Execution can be there, now section 56. Execution of money decree, she cannot be arrested. But there can be other kind of execution in which she can be arrested. Generally, Pardhanashin women will not be asked to appear in the court, but in execution of a decree, we'll read this provision later on. This is not here right now, but this is exemption provision. 132, 133. 132 relates to women and 133 relates to, in between this observation which I made today in my class, this is WhatsApp message, cognizance for extension of limitation suo motu writ petition civil 3/2020 dated on July 10, 2020. Observed that service of notices, summons and exchanges of pleadings and document is required of virtually every legal proceeding, and that the service of notices, summons and pleadings have not been possible during the period of lockdown because this involves visits to post offices, courier companies or physical delivery. The court therefore considered it appropriate to direct that such services may be effected by email, fax, commonly used instant messaging service such as WhatsApp, Telegram and Signal. However, if such services are made by means of said instant messaging service, then in addition thereto, the service of the same document must be made via email on the same date. Email on the same date. So, email is more authoritative. WhatsApp can be one such. So, again, I am dropping this in your app. So, please read this. This is very brief information, but I am loading this in app so you can read it. Is this clear? So, you have seen this order 5, rule 4. Just have a glance. This is your duty, my dear friend. I am having less duty. You are having more duty here in order 5. I have told you. Order 5, summons to be either to settle issue or for final disposal. See here, the court shall determine at the time of issuing summons either it shall be for settlement of issue or for final disposal. Settlement of issue, I have told you, order 14. Final disposal of the suit, that is order 15, and summons shall contain a direction accordingly. In every suit heard by court of small causes, the summons shall be for final disposal. They will not, in court of a small causes, they are not going to issue summons for settlement of issues. No, no. Court of a small cause is court of less jurisdiction, a small jurisdiction. The process should be speedier. So it is for final disposal. So these are preliminary questions. Fixing day for appearance. So day shall be fixed with reference to the current business of the court. Court is very busy, court is not busy, place of residence of defendant if he is living near or he is living farther, and time necessary for service of summons. And the day shall be so fixed as to allow the defendant sufficient time to enable. So what factors will be taken into account in fixing the day for appearance? That is the question. What factors will be taken into account for fixing the date of appearance? Order 5, rule 6. The busyness of the court, the distance between the court and the defendant, Summons to order defendant to produce documents. The summons to appear and answer such shall order the defendant to produce all documents or copies thereof is specified in Rule 1A of Order 8 in his possession or power upon which he intends to rely in support of his case. So summons can be issued to appear and answer shall order the defendant to produce all documents. In certain cases, plaintiff may refer a document which he may not have in possession and defendant may have been his possession. So court may ask the defendant to produce that document. Like suppose we have a case on contract and the original copy of contract with the defendant, so the court can ask him to produce that. On issue of summons for final disposal, defendant to be directed to produce his witnesses because it is for final disposal. So how will you dispose case finally if you do not produce your witnesses? So it says where the summons is for final disposal, it shall also direct the defendant to produce on the day fixed for his appearance all witnesses upon whose evidence he intends to rely in support of. So you bring all your witnesses. Delivery of summons, service of summons, see the heading. Proper officer to be served, bailiff, process server. Just read it, nothing great. Rule 3 you have already seen. Registered post, courier service, no? Rule 4 you have seen outside the jurisdiction. Just read them, nothing great. I have written this in your meaning part also. Summons given to plaintiff for service, that is Rule 9A. Dasti summons. This is asked in your examination, my dear friend. Dasti summons. Dasti summons. Dasti summons. Dasti summons. Dasti summons. Then so Rule 9A is Dasti summons. यही question पूछता है ना, where is Dasti summons prescribed? Can plaintiff issue summons also? Yes. If he is not able to do it, then the court will issue summons. So these are very simple things. By delivering or tendering a copy signed by the judge or such officer as he appoints in this way and sealed with the seal of court. I have already told you summons has all these things. Service on several defendants. तो सबको करेंगे, each defendant. Service to be defendant in person when practicable or in his agent. Rule 12. Service on agent by whom defendant carries on business in a suit relating to any business or work who does not reside within the local limits of jurisdiction. Now, your master is living in Bangalore and you are doing business in Delhi and cases related to Delhi, so to whom I should serve the summons? On his manager, on his agent here in Delhi. It says issued on service on any manager or agent who at the time of service personally carried on such business or work for such person within such limits shall be deemed good service. For the purpose of this rule, master of a ship shall be. अब देखो ये सब, you are not required to memorize all these things. Use your common sense, my dear friend. If I am doing my business through manager someplace, suppose you open an institute in the name of Ambition Law Institute in Bangalore under Ambition Educare Private Limited. So if there is anything which is to be done there, will you come to Delhi or you will deal with Bangalore office? Obviously, you have common sense and you will say, I will deal with Bangalore office. So that is quite commonsensical. This is very simple, very general. So you apply your mind a little bit. Nothing great in these things. Just application of mind. Service or on agents in charge in suit for immovable. Where in a suit to obtain relief or compensation for wrong to immovable property, service cannot be made on defendant in person. And the defendant has no agent empowered to accept the service. It may be made on any agent of the defendant in charge of. There may be any person who is taking care of that property. There is no authorized agent. He is having a caretaker, so you serve on caretaker. And he is residing outside India. He is living in London. He is living in Massachusetts, not in India at all. So, but he has property here. Order 5, Rule 15, I said extended service, adult member of defendant's family. It can be male member, it can be female member. In CRPC, it is only male member, not female member. And here it is said servant is not a member of the family within the meaning of this rule. Person served to sign the acknowledgement. The person to whom it is served, he will sign the acknowledgement, and that is how you will prove to the court that I have served it. Order 5, Rule 17, substituted service, I have already told you. Substituted service without the intervention of court. Endorsement of time and manner of service, the serving officer shall endorse or annex. Examination of serving officer. Substituted service, Rule 20, here the court will order this. In Rule 20, court orders. Effect of substituted service, it is equally effective. Where service substituted, time for appearance to be fixed. Court shall fix the time for appearance. Service of summons where defendant resides within the jurisdiction of another court, so you can send it to another court and another court will issue it. Service within presidency, town of summons issued by courts outside. Nothing great. Service duty of court to which summons is sent. So that court will issue this, will serve the summons and will record the proceedings and will return it to the court to which issued it. Service on defendant in prison, I told you, delivered or sent by post or by courier service or by fax or by EMS or by other means to officer in charge of prison. Service where defendant resides out of India and has no agent. Service where defendant resides out of India and has no agent. Service where defendant resides out of India and has no agent. Where the defendant resides out of India and has no agent in India empowered to accept service, the summons shall be addressed to the defendant at the place where he is residing and sent to him. Service where defendant resides out of India. Rule 25. There can be such things. So I was just telling you that, see, order 8, it is written again. I'll give you in this. You drop this in app and you remove that. उसको हटा दो और इसको डाल दो. So where defendant resides out of India and has no agent in India, summons shall be addressed to defendant at the place where he is residing and sent to him by post or by courier service as may be approved by High Court, or by fax or by electronic mail or by other means like we said, this WhatsApp. No? Nothing great. Service in foreign territory through political agent or court. That can also be done. You just have a glance. These are not important things at all. But you can have this. Rule 30 is a little important. Substitution of letter for summons. So here you are not issuing summons. You are basically giving a kind of request. You are sending a request. You are not issuing summons. You are giving a request. Court may, notwithstanding anything herein before contained, substitute for a summons a letter signed by the judge, where the defendant is in the opinion of court of a rank entitling him to such mark of consideration. Will you send a summon to everyone? Suppose you have some concern or some problem, how will you address me? Me being your senior friend or teacher or advisor, whatever. So if there is anybody who is senior to you and who deserves respect, do you order him that you come and you do this? You will make a request. So that is what Order 5, Rule 30 says. This is a request basically. Summons may not issue anything in paper content, substitute for a summon a letter. So we'll issue letter. Substitution of letter. We'll write a letter. By the judge or such officer as the defendant of a rank All particulars which is there in summons shall be here almost. A letter may be sent to the defendant by post or by special messenger. A letter may be delivered or sent to such agent. All right. So, letter may be sent by post or by special messenger. So, are we clear about summons or not? Tell me. Are we clear about summons? If we are clear about summons, then we'll begin another topic tomorrow, not today. Written statement, set off, counterclaim. A written statement, set off and counterclaim, my dear friend. And I have requested you to solve the questions also. You please solve the question. Now start solving the question and let us take question one by one and we'll answer and address. You please drop all your question in WhatsApp now. WhatsApp group, no individual communication, please, my dear friend. It is not possible for me to look into individual communication and to respond to anyone. I am seriously sorry for that. I really feel bad about this, but I'm helpless, my dear friends. So please drop the question in WhatsApp group. You have WhatsApp group with other friends. You please drop the question there without considering this, that your question is good, bad, whatever. You are entitled to drop a question. It's your right to ask questions. And it is my humble duty to answer all your queries and concerns. This is what Institute has directed me to do. Is this clear? And to be an honest teacher, you have to be careful about the questions of students. So now it is question time for you. You please write all questions in WhatsApp group between 9 to 9:30 in the evening. Generally you do it. You can do even otherwise, but generally you do it between that time. But you can drop question even otherwise, but generally you do it within time. That is better, fair. I can look into the question once and I can respond to that. 9 to 9:30 in the morning also. So if you drop many questions, I will take up questions also in next class. Is this all right? Now you have covered order 1, order 2, order 3, order 4, order 5, order 6 also, except order 6 rule 17, which I'll be dealing with separately. Amendment of pleading, very important topic. And I have recorded a very good lecture for you. That will be recorded lecture for you because I have recorded a few cases there. So I hope that you will give me that much concession that as I have done wonderful work in recording of the cases, I will get benefit of that. Order 6, rule 17, I said. I'll give you that lecture, don't worry, but not right now. First we'll deal with order 8. Order 8. And then little bit this order 9. And 10 also, not big, and then order 6, rule 17 also. Is this clear? अभी का कोई सवाल है तो बताओ. Drop all question in WhatsApp group. Preliminary mains. I will answer them topic wise. Like I will take parties question first, then order 2, rule 2 question second, then order 7, rule 11. These are important topics. So order 2, rule 2, you solve all question. Order 7, rule 11. Order 2, rule 2 is a question which is fixed. Section 9 is very important. Jurisdiction is very important. So all those topics which you are reading here right now are very, very important. Later topics may not be that important, but these topics are very, very important. Section 9A nahi hai, rule 9A. Pragya Rai, without thinking, don't ask question. This is the rule 9A. If one court has jurisdiction, another should not have. If I am a teacher, another teacher should not be there. If you are a student, another student would not be there. अरे दोस्त समझो बात को. क्यों? यदि alternative arrangement से court is also issuing summons. Plaintiff is interested party. If he is serving summons, it's good for justice. Justice will be done in quick time. Plaintiff is interested And defendant is also honest, so plaintiff goes and serves summons and defendant accepts. The quicker delivery is there and faster justice is there, so it's good. Now you read all those rules which I have told you, not all rules. आप पूरी दुनिया की कहानी नहीं पढ़ लेंगे कभी भी, इतना ही पढ़ना है जितना हमने बताया है. हम बताते हैं आपको क्लास में, आप पता नहीं क्लास में क्या सुनते हो क्या करते हो, आई एम नॉट श्योर. But in class, I share everything what is important and what is not. I have also said right now, order 5, rule 15 is important, rule 17 is important, 20 is important. अभी तो बताया मैंने, अभी तो आपको ध्यान, which rules I covered carefully. Order 5, rule 1, I covered carefully. I covered carefully or not? Order 5, rule 9, rule 9A. Order 5, rule 17. Order 5, rule 20. जो मैंने where I am stressing in the class, that is important. Where I am not stressing, that is not important. So please try to understand that. मैंने आपको बताया, आपने पूछा, मैं फिर से बता रहा हूँ. Order 5, rule 30 also. But there is nothing in rule 30. Order 5, rule 1. Order 5, rule 4, I told you. Order 5, rule 5, to settle issues or for final disposal. No? Then order 5, rule 9. The common sense है 9A. Then 15, rule 15, rule 17, rule 20, rule 20. Then rule 30. Then rule 30. Rule 30. Summons for appearance and summons for final disposal. Difference. So summons for final disposal is for final disposal. The suit will be disposed of as per order 15. And summons for appearance, you will appear and you will file written statement. No? You will file written statement. I have asked you to appear and there may be reason for that. We'll explain the reason also. Now, for what we have done, we have issued summons for final disposal. It means we want to decide the case finally. And we have asked you to appear, so it means you will file WS. You file WS, written statement, because audi alteram partem is the rule. All right. All right, my dear friend. Oh, now you read more and you ask more questions. Is this clear? You read and you ask more questions, my dear friend. सारे लोग खुश रहेंगे, आप एग्जाम ढंग से देंगे, नो वरी। आगे हम लोग पढ़ेंगे, उसके बाद एग्जाम देंगे, तब मजा आएगा। So we should not be in hurry. First you prepare well, then plunge in examination. Rest you can appear in examination for your experience. Nothing beyond that. Is this clear?